आनी हांवें सुप्रीम कोर्ट जजमेंट सगळे वाचून फॉर प्युरिटी ऑफ इलेक्शन्स हें जायना. काल ताका रिप्लाय करूंक जायना आसलें आनी टायम मारला आनी 5 म्हाका दिसता ताणें रिप्लाय दिला, आमकां दिलो ना. सकाळीं आमी हियरिंगाक गेले तेन्ना म्हाका रिप्लाय दिला आनी रिप्लाय कॉपी तुमकां सर्क्युलेट करता, तुमकां वॉट्सॅपाचेर धाडटलो. रिप्लायान तो मानून घेता, हें इम्पॉर्टंट, तो मानून घेता की हांव वाचतां तेगे उतरां, हो रिप्लाय तेजो फायल केलो तो, तेणें सायन मारला. तेणें टेक्निकल प्लीज घेयले that this is not a ground for rejection. Mere registration of FIR without charge being framed is not a suppression. So we are technical ground. But important, maka kit important. In the present case, it is alleged that an FIR number charge, no charge has been framed. The FIR is itself is under challenge by me in criminal writ petition number 721 of 2025 before the Honorable Bombay High Court at Goa. No charge sheet is filed, no cognizance and no summons is issued. म्हणलो आमी घायले ते डॉक्युमेंट घायले ते आमी फॉल्स डॉक्युमेंट घायना, आमी फॉर्टिफॉन काय म्हणलो ना, आमी दाखय आहा ते दाखयला आनी तूं मानून घेता हें करेक्ट आमी म्हणलं तें. आतां हिशोब कितें, सेक्शन खंयचे आहात ते आतां सेक्शन BNS एक्टाचे ओल्ड सेक्शन 420 जाता, 420 चिटींग आनी 406 क्रिमिनल ब्रीच ऑफ ट्रस्ट. सो आतां हें आहा जाल्यार म्हणलो तो मानून घेता की FIR रजिस्टर आहा कर्नाटका तेजे चिटिंगाचे आनी क्रिमिनल ब्रीच ऑफ ट्रस्ट. तो मानून घेता की आमी ऑब्जेक्शन ऑन फॅक्ट्स काडले ते सामके आसा, म्हणलो काय आमी फूट मारलो ना. आनी रिप्लाय तेजे कितें, दीस इज नॉट अ ग्राउंड फॉर रिजेक्शन, तें वेगळें, तें आमचें पळोवपा जाता. वी कॅन सी लेटर ऑन वेदर दॅट डिसिजन ऑफ RO इज रायट ऑर रॉंग. That will be seen later in an election petition as and when it's required, if at all he wins an election. Today we can't challenge that order, it remains. आता एज फाटल्यान ऑब्जेक्शन हांवें काडटा तेन्ना हांवें पासून उपरांत एक सांगलोलें की FIR राजस्थाना रजिस्टर केली. FIR राजस्थाना रजिस्टर केली ती हांवें म्हणलोलें पासून ते FIR नंबर 187 of 2024 आणि ते सेक्शन आहात ते 420 चिटींग आणि 406 क्रिमिनल ब्रीच ऑफ ट्रस्ट. एका उतर ना, हें फोटो म्हूण ना, हें फाल्स म्हूण ना, डॉक्युमेंट आसा. सो आतां हें सेकंड हेज भायर हांवें कितें बरयलें, एक नोटीस येयल्ली म्हणून हेचे कितेंचे टाटा कॅपिटल हावसिंग फायनान्स तेणें तेगे पोजेशन तेगे बाटाचे पोजेशनाक घेवपाक तें नोटीस काडली. हांवें तें दाखयलें आनी हिंगा म्हणटा अमावंट एंड डेट ऑफ डिमांड नोटीस एज ऑन 14/12/2023 an amount of rupees 38,18,413 तें देणें and date of possession 27 May 2023. Right or wrong, whether you agree or you don't agree, you challenge or you don't challenge, these are documents I am putting in public domain for you to know. So मुगे question कितें, एक पाटी हांव डॉक्युमेंट दिता, तूं वय म्हणटा, उपरांत तुमचें कितें कोण म्हणून जाता, काँग्रेस पक्ष डॉक्टर बाटिकार आनी आमी फोटो मारतात. This is completely wrong. I can understand that you can say irrelevant objections, you can say something else, but you can't say आमी फोटो मारतात. This is a complete lie, not only of people who have made this statement, but even on behalf of the party it was being made that this आमी फोटो मारतात. मागीर आतां फकत कॅन्डिडेट तेंचे पक्षाचे लिडर आहात ते जातीचे उलोवपाक लागले. हांव जातीचे कांय म्हणना, कित्याक आमी गोंयकार तूं जाणा, आमी जात धर्म केन्ना चोयना, आमी गोंयकार म्हूण पळयतात आनी गोंयकार म्हूण आमी वयतात फुडें आनी आमचें लायफ डेली तेशेंच आसा. हांव तुमी जाणात की हांव सगळें खबर आसा, हांव केन्ना कोणाको विटनस करना आनी हांव केन्ना चिंतना कोण म्हजे फुडें येयलो हे धर्माचो ते कास्टाचो तेश कोन्न केन्ना केस जाल्या नाल्यार काम जाल्या हांव सगळ्याचें काम करता. म्हूण म्हाका एक हें बरें लागना की हे एक विक्टीम कार्ड म्हूण करूं सोदतात दाखोवपाक की आमी तेजेर फार मारूं सोदताले आनी तांकां काबार करता. तुमकां सांगलां तेणें की तेणें हितेश नायक आम आदमी पार्टीचो तेणें एक आदवोगाद हाडलो. गोंयकार न्ही तो, म्हाका दिसता तो कोण भायलो, हांव कांय वळखना ताका. आयिल्लो तो स्पेशली रितेश रवी नायकाचे फॉर्म ऑब्जेक्ट करपाक. आज तूं भंडारी समाज म्हणटा जाल्यार तूं कोणा हाडटा रवी नायकाचे फॉर्म ऑब्जेक्ट करपाक. ऑब्जेक्शन काडला तो आयला तुगे डिफेंड करपाक. तो चुकून आशिल्लो की हांवें ऑब्जेक्शन काडलो आशिल्लो थिंगा. तूं येयला हेगे ओपोज करपाक. ऑब्जेक्शन काडला आनी काल मातसो म्हणलें ऑब्जेक्शन काडलें, ओवररूल जालें आनी रितेश रवी नायकाचे फॉर्म एक्सेप्ट जाले. सो एश कोन्न तुजें डबल खेळूंक जायना. तुमचें तें इसरोन तुमकां खबर ना कितें जालें तें आमगे रिटर्निंग ऑफिसर फुडें कोणा धाडला त्या मनशाक, पक्षांनी धाडला ओएन हाडला हांव जाणा. पूण हें आसपा जाय. आनीक एक सांगूं सोदता हांव तुमकां. आयज हांव पळयता तेन्ना रिटर्निंग ऑफिसरान फुडें फॉर द लास्ट हियरींग म्हाका वाटेर कोण आनी कितें धाडला म्हूण आयज तो पॉयंट काडूंक जायना. आनी कायद्यांनी हांव तुका सांगता तुगे एफिडेवीट ऑन एसेट्स ऑन युअर प्रॉपर्टीज ऑन युअर बँक बॅलन्सीस फाल्स आहा जाल्यार इट इज नॉट अ ग्राउंड फॉर रिजेक्शन ऑफ अ नॉमिनेशन. देखून हांव तें केन्ना काडना. तुगे एक बँक अकाउंट सुटलो, तुवें पयशे दाखयला तें आमी ऑब्जेक्शन काडना. सुप्रीम कोर्टान डिफरन्स केला बिटवीन सप्रेशन of criminal antecedents versus non-disclosure of assets or filing false affidavits. So they call like the argument first part आशिल्लो. आयज हांव म्हणटालो वाटेर आशिल्लो तेन्ना म्हाका आनी कोणाक हें धाडलां की लोकमान्य मल्टीपर्पज कोऑपरेटिव्ह सोसायटी एक आर्बिट्रेटरा फुडें केस घातली आनी थिंगा 5 जाणां रिस्पोंडंट म्हूण आहा. एक गितेश गोकुलदास नायक, एक अभिजीत आनंद शिरोडकर, एक बोनावेंतुरा डिसोजा, एक रोमा गितेश नायक, एक सुधीर त्रिलोकनाथ दुबे. आनी हेंचेर सगळ्याचेर opponents 1, 2, 3, 4, 5 shall jointly and severally pay to the disputed सुप्रीम कोर्ट कितें म्हणटा? सुप्रीम कोर्ट म्हणटा लोकांनी सांगूं जाय म्हणून कॅन्डिडेट सगळें डिस्क्लोज करून लोकां फुडें वचपा जाय. वयता तेन्ना हें क्लियर आसपा जाय की कितें केस आहा, तुगे एसेट सगळे तूं लोकांक दाखयता जाल्यार आनी दाखयना जाल्यार मुगे मनान कितें हांव चिंता एक कोण कॅन्डिडेट हें सोड तूं खंयचो कॅन्डिडेट गेलो जाल्यार आनी तो सामको रिणां बुडलो जाता आनी ताका पयशे नाय जाल्यार इलेक्शन कितें करून झगडटा लोक चिंतलो. पयशे कोण दिता, पयशे उसोन हाडटा आनी मागीर पयशे कितें करून रिकवर करतलो, तेगे लोन कितें करून फारीक करतले, लोक चिंतलो हें सगळें. देखून सुप्रीम कोर्टान सांगलां लोकांक कोण दी हें सगळें. बरें तूं सामको गरीब जाल्या पासून कॉन्टेस्ट कर पूण लोकांक कोण दी. लोकांक सांगनासतना इतलें रीण आहा तेन्ना तूं इलेक्शनाक वयता आनी बसता आनी तूं सांगता आमी फॉलो मारता. हांव डॉक्युमेंट दिता, मुगे डॉक्युमेंटा भायर हांव कांय उलयना. देखून हांवें म्हणलां हें सगळें आमी सांगलें तें सच सांगलां. आनी आनीक एक वाचूं वयता तुका तें एफिडेविटाचे फॉर्म आहा अशें एक statement number 5. I am not accused of any offences punishable with imprisonment for 2 years or more in a pending case in which charges have been framed under me by the court of public. So and so सगळे आडू जाय कितें in which charges have been framed by the competent court of competent jurisdiction. आता हे सगळे हांव म्हणटा केन्ना हुंय कोण वयत जाल्यार आमी पासून कितें एक FIR जाले पासून आमी डिस्क्लोज करता FIR आहा FIR ना जाल्यार तूं क्लीन आसा म्हणल्यार तुगे क्रिमिनल रेकॉर्ड ना जाल्यार दाखोवपाक जाय लोकांक कोण दी केस लिहिली तूं लोकां पासून झगडपाक गेलो रस्ता रोखो लाठी चार्ज जाल्या तेन्ना मागीर तुजेर FIR जाल्या हे लोकांक पूण फायनान्शियल ट्रान्जॅक्शन आहा पयशाचे खबर आहा जाल्यार आनी थिंगा चिटिंगाची केस आहा लोकां देणे म्हण तूं चॅक बाउन्सिंग दाखयला नो प्रॉब्लम तूं लोकां देणे जालें आनी थिंगा केस घायली मागीर लोकांनी चिंतूंक जाय आनी ते सुप्रीम कोर्ट म्हणटा लोकांक खबर आसपा जाय कसलो कॅन्डिडेट म्हणून आनी मागीर कसलो कॅन्डिडेट इलेक्शन बसता आमी मत दिवपाचें मत दिवपाचें न्ही म्हणून इतलेंच
तुम्ही म्हणले FIR disclose करू ना. Is it mandated to disclose the FIR?
See, when the Supreme Court wants criminal antecedents to be disclosed, then it is my contention that all your, if you don't know, I can understand. Sometimes like FIR on file, to police in Chennai, you may not know. Understanding what it is. But when you know the FIR, you are challenging it in court, then you have knowledge. Then you can't say, I don't know. See, the fact is not, FIR is known or not known. The question is it a fact that there is an FIR or not? You understand? There is, no? And there is a case of what? 420 FIR. So that is important. That is what we have to see.
Altogether, how much loan we have taken?
हांव एक सांगता तुका आनीक हांव देखो हांव म्हणटा हांव डॉक्युमेंट नासतना बेश्टो कांय म्हणना म्हाका आनी कोणें आनी कितें सांगलां कितें आनी कितें आसात म्हूण तेचें पूण अंटील आय व्हेरीफाय वीथ फॅक्ट्स हांव कितें सेंटेन्स स्टेटमेंट करना आय डोंट वॉन्ट टू सेन्सेशनलायज इट आय डोंट वॉन्ट टू मेक स्टेटमेंट वीच आर रॉंग आनी बेश्टे कीप इट इन स्पेक्युलेशन दॅट आय विल नॉट नो इफ आय एज ऑफ नाव there is, I think, in his affidavit he has said about 22 lakhs already decreased against him. I think about 22 lakhs, 17 or 22 lakhs. That is subject to correction. Then, what I have seen here is, in Lokmanya, he is owing, not of Lokmanya, that Tata Capital, he is owing 38 lakhs 18,413 with interest. I don't know from which date it is coming, but that notice is of 2024. And Lokmanya case, which is a notice of 2021 of the order of 2021, shows 22 crores 97 lakhs 4,812. So this is what it is. Such huge amounts. Maybe sometimes somebody has a huge windfall and he can just pay in one installment. Maybe I don't know what are the means how people can pay. But sometimes I think also when you get money, half will go for income tax. It's such huge amounts. So you have to get really very huge amounts so to be able to pay this, because it will be about 50 lakhs and then you are going to be 50%. You understand how the taxation works? So 50% goes for tax. So what will remain for you to pay is what remains, if these are the only loans.
ओके वेन्झीन एक स्टेटमेंट केला की आमकां फक्त एकूच ऑपॉर्च्युनिटी दी म्हणून 8 म्हयन्यांत प्रूव करपाक लागून.
So Wenzi should have, first thing is, you all rightly asked the question to Captain Wenzi that you all are supposed to be in alliance. So I think Captain Wenzi should have spoken with our leaders before fielding the candidate. So I can't make a statement on that because that is my party will reply. But personally, I feel that we all need to be together because we have one common enemy. The common enemy today for us is the BJP. So my statement is, anybody who wants to defeat the BJP stands with us. anybody who's not with us definitely wants to defeat us and make sure that BJP wins.
Alvares, with this highlighting of this issue, were you expecting disqualification of the nomination?
We put up our case, and we definitely expect the best. And if we don't get a favorable order in our favor, sometimes we have also not got all favorable orders, we have gone to the higher courts. So I've said that option is still available in the event he should win. But I would like to get this tested. Let me be honest with you, it's not for A or B or this case. It is for purity of elections I would like to get this tested. Because Supreme Court uses this word, that we need to clean the system. And I will just tell you the word which I had read today. I actually give me a moment, I'm not sure exactly. This is a judgment in Civil Appeal 13015 of 2024, Ajmera Sham versus Goa Lakshmi, Supreme Court judgment. And this is what I'm going to read for you. That's the last part. Paragraph 11 I will read for you. Judicial intervention in election disputes concerning disclosure of information as discussed above was prompted by the quest for sanitizing the electoral process by eliminating polluting elements by making candidates' criminal antecedents public. Aiming to prevent criminals from participating in elections to maintain purity of the election process, the essential for proper functioning of parliamentary democracy, the court was compelled to, in its extraordinary power, issue specific directions. Consequently, not only the disclosure of criminal antecedents, but also related obligation to disclose assets, liability, and education qualification election candidates becomes mandatory. The knowledge of the criminal antecedents, assets, and education qualification of the candidates by voters certainly invigorates the electoral process, which is ensured by obligatory disclosure by the candidate. However, the court has made a subtle distinction between non-disclosure of the criminal antecedents and that of the assets of educational qualifications. While disclosure of criminal antecedents in the electoral process was the most critical element to maintain the purity of the electoral process, which has to be scrupulously adhered to, disclosure of assets and educational qualifications were considered as attending supplementary requirements to strengthen the electoral process, for which there will be certain scope for consideration as to whether it is of substantial or inconsequential nature. So this is what the Supreme Court says. That's what I'm talking. When you talk of purity of election, this is how it works.
And Kalu sir, today Aam Aadmi Party asked for the apology from your side for doing the allegation on the debation.
Have I made any false statement? If I make a false statement, I'm the first one to apologize. If I have not made a false statement, and I think they have not understood what I have said. I think they have not heard. And sometimes की ज़्यादा लोग कहाँ बेस्टो मुर्पा कि यानी एष्ट मुर्ला मैं दूसरों चारोता यानी किते मुंटा. So sometimes you should not jump to making statements and asking for apology. Sometimes that is, I look at it politically like a strategy, just to browbeat, lock up photo pa, false statement kala. And you see, I saw somewhere that Congress is peddling lies, How can we lie? I told you the truth. I showed you documents. So on what should one apologize? I can understand. I'm ready to say apologize if I said something wrong. 420, cheating, 420, that's all. What else is there? Have I said anything wrong? Have I showed you any false document? Have you said any document is false? Have you said that what statements I have made are false? See, maybe after 2 years, maybe after even 6 months, maybe next day also, maybe this case may be quashed. I don't know. I'm not coming on that. Today, the question is on the day you file the nomination, what is the statement? That is the law.
Okay, thank you.
Thank you.